Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos we are talking about the petty offense exception. Now, one question that comes up periodically is, people find that they can't come into the United States even though they didn't commit a crime, but they admitted to the elements. I have people who we're at an interview. They've waited years and years and years for the visa number to become current. And finally, they get their medicals and they're at the interview. But at the medicals, the doctor says, "Have you ever, done drugs?" And the person say, "Well, I did, for example, some marijuana a few years ago, and other than that, I didn't really do anything." Well, the admission of the elements of a crime, even if it was to the doctor who made the medicals before you got to the actual visa officer, generally will make it so someone is inadmissible based upon those particular admissions. So the question is, if you admit to a particular crime and it turns out that that particular crime would fall under the petty offense exception, then you cannot be inadmissible based upon those admissions. So if that does happen, you need to find out what it was you admitted to. So for example, if you admitted to a petty theft crime, if you said, well, when you were 22 years old, you stole some toothpaste from a local Walgreens, and the officer denied you the ability to adjust, saying you committed a crime and therefore you're inadmissible, your argument would be that if you look under the statutes of petty theft, you of course would see that the actual maximum time would be less than a year, and of course you didn't serve any time. You didn't serve at least 6 months or more, and therefore it would fall under the petty offense exception, and you would not be inadmissible because of that admission. Okay, more in the coming videos.